this is Pahuja Law Academy, a famous training institute for those aspirants who are aspiring for, coveted judicial officer post in different states. This academy has the distinction of getting success students, a large number of students, success for a large number of different states of our country. You see, my name is Vijay Kumar Sinha, the senior faculty member teaching the students for the last several years. Subjects which is being taken up for the students, subjects taken up for the student relates to national law today. Relates to law today. And so to begin with, there are two primary questions. Number one is, what is the basic suggested reading national law? It's a large subject. Basic suggested reading. And the second one is, what is the diagrammatic chart? What is the diagrammatic chart for the study of the part 1 of the lecture, that is introduction to suggested reading? I will suggest the student to stick to either of the two books. First book is, the author is A.K. Jain. That is Accent on International Law. Author is A.K. Jain. So you can, you can use this book for your basic understanding. The second, second option, which is also very good, this is the publication of, Central Law Agency. And the title of this book is International Law and Human Rights in Nutshell. National Law and Human Rights in Nutshell. The author is S.K. Kapoor. Now we start with the first title. Let us start with the first title. The first title is Introduction to International Law. Introduction to International Law is draw a straight line. Introduction to law, is subdivided into three important categories. Kindly see the board. Three important. This is three important categories. Three important categories. The three important categories, you kindly see the three important categories. So this is, the title Please kindly see the board. Title is Introduction to Criminal Law. This is the title. Kindly see the board. Introduction to Criminal Law, and this is subdivided into, three important categories. The first, category is to understand or to know the importance of. First, the importance and relevance of this subject matter. Relevance of this subject matter. This is the first one, and relevance of this subject matter, you see. Second one is, this is equally important, you see, understanding of important terms and expressions. Important terms and expression are used in international law. Important terms and expression used in law. This is the second part of the drawn line. You see, important understanding of certain important terms and expressions used in law. The third is equally important, the history and development of history development of law and development of law and development of international law. So you see, whenever you start with the first subject matter in international law, this is titled as Introduction to International Law. Now the introduction to international law it says that this is titled as Introduction to Law. Introduction to international law. As I told you just now, kindly see title of on the board. The title of this first part is Introduction to International Law. Now this title comprised three important items of study. You see, this title comprised, kindly see the board, and I'm just speaking up orally. You see, this title Introduction to International Law is comprised three important items of three important items of study. You see, important items of study. Now you can see on the board, first item is that you should know something about, first of all, to begin with, you should know something about the importance and relevance of this subject matter. देखिए हम फर्स्ट पार्ट में क्या है, इम्पोर्टेंस एंड रेलिवेंस ऑफ दिस सब्जेक्ट मैटर. यानी आप इन अदर वर्ड्स यू कैन से इम्पोर्टेंस एंड रेलिवेंस ऑफ इंटरनेशनल लॉ. इम्पोर्टेंस ऑफ, this is the first item of study with regard to this particular item written on the board? The second, equally important. The second is more important. The reason is that you should first basically understand. You should first basically understand, some of the important terms and expressions commonly used in national law. Because in international law, you'll be confronted with. International law, you'll be confronted with some common terms and expressions. Be confronted with some common terms and expressions used. Because time to time, in every further chapter, will come across terms and expressions. So first important, because keeping in view the importance of these terms and expressions, it is our duty. Under this title, it is our duty. Under this title, that is Introduction to International Law, our duty to make you understand some of the basic terms and expressions commonly used in international. And altogether, there are 7 important terms. You can note it down also. The first term is law of nations, national. This is the first, expression. Law of nations, national law. Second term is state, society, and country. So there are 4 succession, there are 4 terms. State, nation, country. Then we have the next one, that is term is sanction. Sanction, this term is commonly used in sanctions. Then we have the next term, that is transnational laws. Transnational. Then we have the next expression, custom and usages. We have the next terms and custom and usages. Then we have, next expression, public and private in law. Public and private in law. And then we have the last terms and expressions commonly used, that is treaties, agreement and convention use. Treaties, TREATIS, agreement and conventions. So second part, what I was trying to say, I was trying to say in this connection, that the second part, production, the the title international law, the second important items of study is that you should first understand the basic terms and expressions which are, commonly used law, you see. And the item is that is history and development of it. How the law the stable law, but it is not a standstill use. International law is a dynamic law subject to change, growth and codification. This is also known as a dynamic law. So history under this, third item to study, under this third item of study, history and development of international law. This is subdivided into, now kindly see, this is subdivided into 4 parts. Is subdivided into 4 parts. This is Roman 1, this is Roman 2, this is Roman 3, this is Roman 4. So this history and development of international law, this history development of international law subdivided into 4 parts. Subdivided into 4 parts. This is subdivided 4 parts. And the third part divided into 3 schools, 3 important schools. तो क्या है इसको पहले, please kindly come to this title, this part. Please kindly come to this item, the subject matter, that is history development of, that is history and development of international law, you see. That is history development of now history and development of international law, as I have shown you on the board. Please kindly see the board, you see. As I have shown you on the board, you see. This history and development of international law is subdivided into four important categories. 4 important. Roman 1 is contribution international law at the ancient historical stage. आप पहला में लिखिए contribution national law, contribution to national law at the ancient historical stage. Yani, in other words, you can say this item study this item of study is confined to the growth of law at the ancient historical stage. पहला हो गया. This is the first one you see. जब आप whenever you start with the history development of international law, this is the first one you see. Again, growth of international law in the Middle Ages. Growth of law in the Middle Ages. The Middle Ages में within bracket you put it down. Middle Ages within bracket you put it down. You that is 16th and 17th century. 16th and 17th century, you see. And 17th century. Then we have in the third Roman third. This is development of international law. ये तीसरा जो हो गया, please kindly see the board use. The third one is titled as, पहले तो title, you have to write the title use, and that is development of national law in 18th century, giving birth to three different schools of inter. So three, please kindly see the board you see. I'm moving in accordance with the diagrammatic chart provided on the board you see. This item, third item, under the heading History and Development of International Law, is titled as Development of International Law 18th century. Development of international law in 18th century, giving birth to three different schools. You can see on the board I have subdivided into three parts. Item number third is subdivided in three parts. Subdivided into three parts. The first school is known as, के नीचे आप भर दें, please kindly fill it up. First school is known as naturalist school. First school is known as naturalist school. The second school is known as a Groshan school. Groshan is spelled as Grotin. Groshan is spelled as Groshan school. Actually Groshan school consists of, आप यहाँ पर इस बात को please kindly understand, the Groshan school actually consists of followers of Hugo Grotius. Groshan school consists of followers of the followers of Hugo Grotius. Hugo Grotius, as you all know, that's a very important. This, there are several times in judicial officer examinations, there have been questions from Hugo Grotius. So, Groshan school consists of followers of Hugo Grotius. Hugo Grotius was known as the father of modern international law because he published a very important famed book, and so he was known as the father of modern international law. In course of these series, the series on international laws, if you will subscribe, then we'll go through this series of law lecture. This is the first starting part of. Now, during the explanation of the series of subject matter in international law, you'll be able to know the role of Hugo Grotius. You'll be able to know the role of Hugo Grotius. You'll be able to know the important and famed works of Hugo Grotius. So third, as you can see on the board, the third is development of international law in 18th century. Development of international law in 18th century, which gave birth to three different schools of thought, जिसमें हमने I said the first school was naturalist school, the second was Groshan school, and the third school is positivist school. The third school is positivist. Positivist का spelling, we spell the word positivist as Positivist. Positivist school. So while studying this topic, history and development of international law, under the major title Introduction to International Law, we normally cover the development and growth of international law in 18th century, during which there was the birth of three important schools, that is naturalist school, Grotian school and positivist school. And the last one is that is item number 4 under this head, history and development of the item number 4, Roman item number 4 is international law in the 19th, 20th and 21st century. International law 19th, 20th and 21st century. So see, introduction to law once again. So you see, introduction to law, this is lecture 1 part 1. This is lecture 1 part 1. So this introduction to national law is part 1 and this is lecture 1. So let us start one by one. Use the first one, that is first part, the relevance and importance of national law, that is relevance and importance of this subject matter. Kindly see the board, importance and relevance of this subject matter. Use international, this subject matter is important for both theoretical and pragmatic reasons. The underlying magnitude and its pragmatic relevance. The underlying magnitude and pragmatic relevance of this subject matter are manifold. जैसे for example, the first importance is that this subject matter is an important part of academic curriculum. Very important part of academic curriculum. That is, this subject matter is a part of UGC net syllabus. So a person aspiring for academic excellence, the law paper, person aspiring for academic excellence is bound to have a solid theoretical and practical base of interest. I said there are students, there are a few students, there are 20% students who are aspiring for academic excellence also, and they are interested in the teaching career also. So for that they have to clear UGC net syllabus examination. international law as a subject matter and its solid theoretical and practical base. Solid theoretical and practical base is necessary, you see. Second reason, there are aspirants who are aspiring for CLAT LLM, aspiring for CLAT LLM examination, use law test for LLM use. So you get through in CLAT LLM, examination, a good institution, use that is good institution, then this is a stepping stone for, for professional placement. Professional placement. And this exam, therefore, CLAT LLM exam, therefore, also requires the proper understanding of Similarly, there are third point. There are certain states which conduct judicial officer examination. Conduct judicial officer examination. There are certain states such as Uttar Pradesh, Bihar, Uttarakhand, where this subject of matter of international law is part and parcel of judicial officer examination use. Besides Haryana, Delhi Judicial Service, I went through the previous question of Haryana, Delhi Judicial Service use, and I found that there are at least 5 questions from this. At least 5 questions. So even in connection to judicial officer examination use, covering certain important states use, the basic knowledge of international law necessary. Basic knowledge of international law is necessary. Next, this subject matter that is international law, the major part of Indian administrative service exam. This is in optional paper, law optional paper, major part of Indian administrative officer examination, or civil service law optional. UPSC, Union Public Service Examination, optional in UPSC, a very encouraging subject. Questions are strict. Questions are interesting. questions are marks fetching, the result, the percentage of the result is very high. So this is the fourth region, and then we have the fifth region. I mean, you see, I'm talking about, I mean, you must know, talking about the relevance and importance, talking about the relevance and importance, about the relevance and importance of, I mean, this subject matter, you see. And this was, I mean, the fifth important region, you see. Next, the sixth important region is that this international law is an important part of general knowledge and current affairs, you see. International relation, international conferences, international summit is an integral part of both current and static general knowledge use. An integral part of both, I mean, static and current general knowledge use. This is a part of, I mean, general studies for all kinds of, this is a part of general studies for all kinds of judicial and civil service examination. See, there is a important, I mean, chapter which is, I mean, separately studied in law. There is an important chapter, I mean, in law, and that is the national organization and its transactions. National organization and its transactions. Under which we study the multilateral treaty, under which we study the regional organization, under which we study the specialized agency of UNO, under which we study the six important organs of UNO. Well, under this chapter, the international relation, conferences, diplomatic mission, important summit, ऐसे उदाहरण के तौर पर, I mean, joint declaration of Delhi G20 summit. This is an organization. And there was a successful, I mean, joint declaration New Delhi. Which came forward with certain, I mean, concluding agreement among, I mean, concluding agreement among all, you see, was the greatest achievement, diplomatic achievement of, I mean, India, the I mean, holding the presidency of G20. You see. So under the, I mean, under the international head, under the international head, you see, under the chapter international organization. You see. And last but not the least, there are different topical essays. Now, in all judicial officer examination, there are different questions on, different topical essays. Different topical essays in relation to, the aforesaid areas used. Kai sare, there are number of topics used where question is important. Topical essays are important. They are part and parcel of civil and judicial competitive examination. They are part and parcel of civil and judicial. So what I am trying to say, you see, the first part itself, you see, I am trying to, under this head, introduction to international law, first of all, what I am trying to say, I'm trying to say that the first important, item which you should study, the first important item which study is importance and relevance of this subject matter, that is international. Now you can see the board, the second item. Now come to the second item. You can see the board, second item in this connection use. The understanding of certain important terms and expressions. You see, whenever you start with any subject matter, the law paper, any subject matter, whenever you start with any subject matter, it is your duty to first locate the important terms and expressions which you should understand basically. These terms and expressions which I said earlier, these terms and expressions are, commonly used in, say for example, let us start with the first term use. The first term, two term. The first expression is to express. Law of a nation and international law. These are the two, expressions. So, first important point is that these two expressions are commonly used. These two expressions are commonly used and is precisely synonymous expression. दोनों का meaning equivalent है, you see. Precisely synonymous expression use. This synonymous expression, equivalent expressions, equivalent term, which refers to, which refers to one and the same thing. The term, now here is the location of objective. The term international law, the term international law, the term international law was coined for the first time. The question, this is the question. Was coined for the first time by Jeremy Bentham. Was coined for the first time by Jeremy Bentham in his published book. Jeremy Bentham was a, great English philosopher. Jeremy Bentham was the, if I can remember, you see, might be remembering also. Jeremy Bentham was the propagator or propounder of, a famous philosophy, that is the philosophy of utilitarianism. Use utilitarianism. Jeremy Bentham was the, propounder of the doctrine of utilitarianism. utilitarianism, by this ism, by this expression, he meant, by this expression he meant greatest happiness of the greatest number. Greatest happiness of the. Now, I mean, this term in law, this is what I mean. I'm trying to locate the question here. You see, this term national law was coined for the first time by Jeremy Bentham. Was coined for the first time by Jeremy Bentham. Was coined for the first time by Jeremy Bentham in his published book. So you should also name the name. You should also name the published book also. Name the public book. This book was published in the year 1789. Book was published in the year 1789. Namely, आप inverted में लिखिएगा, namely principles of morals and legislation. Namely principles of morals and legislation. Principles of morals and legislation. He explained that the national law, उसने इस बात को explain किया. He explained that national law is mutual transaction. Inverted में आप इसको note करेंगे. Mutual transaction of sovereign state. Mutual transaction of sovereign states. Mutual transaction of sovereign states. Mutual transaction of sovereign. Mutual transactions. Try to understand this term with the inverted commas. You see, mutual transaction of sovereign states. Actually, it means regulation of interrelationship, official interrelationship. Regulation of official relationship between sovereign states. This is the mutual transaction of sovereign states. Regulation of, official relationship between sovereign states. This is what we mean by. This is what we mean by a mutual transaction of sovereign states. So as per the classical jurist, classical here it means traditional. As per the classical jurist, it is a law. National law is a law. As per the classical jurist, when I use the word classical, I mean jurist. Again, we will study in the second part. Second part is titled as Theoretical Foundations of Interpretation. As per, it says that as per, the classical jurist, it is a law. It is a law that regulates the relationship of states. Regulates the relationship of states with one another. One another. So the expression law of nations. So the expression law of nations. So the expression law of nations and international law are synonymous expression. One and the same. Are synonymous expression which refers to, are synonymous expression which refers to body of rules and principles. Body of rules and principle. No minute. Wait 2 minutes. Body of rules and expressions that regulates the relationship. Rules and regulations that regulates the relationship, that regulates the relationship between sovereign states. Regulates the relationship between sovereign states. So, I mean, whenever when you start with you, I mean, this first part, that is introduction to international law. So, pahla, I mean, the first important, I mean, term and expression, the first important terms and expression related to, I mean, the two expressions, as I told you, the two expression number one is, the two expression number one is, the two expression that is number one is the law is international law, and the second is law of nations. And these two terms, international law and law of nations, are synonymous expressions. Synonymous expressions which together refers to the body of rules and principles, that regulates their relation, body of rules, principles that regulates the relationship between sovereign states. So, you see, the whole object behind this lecture is, and this series will continue, you see, the whole object behind this lecture is, you see, is to locate whole object behind this lecture is to locate, I mean, the important areas which together constitute a subjective or objective question. Subjective and objective questions. Similarly, there are four further terms: state, society, nation, and country. Similarly, there is a term and expression sanction. Similarly, there is a term and expression transnational laws. Transnational laws. Similarly, there is an expression custom and usages. Similarly, there is an expression public and private internal laws, or last but not the least, public and private internal laws, and last but not the least, treaties, agreement, conventions. So you see, the whole idea behind, I mean, in this part 1, lecture 1, the whole idea behind this, in this part 1, lecture 1, is to understand basically, I have started today to understand basically certain important terms and expressions. Commonly used in international law, you see. So the chart is clear. You see. The first part is titled as, once again you try to understand, the first part is titled, इसलिए आप वहां लिख देंगे, this is part 1, lecture 1. is titled as Introduction to International Law, which is subdivided into 3 categories. Introduction to International Law. You see, competitive examination. See, competitive examination, an examination of understanding the fundamentals. Understanding the fundamentals. So, second, under this head, I mean, what is important? Under this head, you have to understand important terms and expression. And the last one is, because you have to study also, you must have some background also. You must have some background of the history and development of international law, I mean, through the years. So I have categorized it under 4 heads. Ancient, Middle Ages, 18th century, and last one is 19th, 20th and 21st century. So yeah, you see, this part 1 is aimed at. This part 1 is aimed at, I mean, introducing the students, the introduction to international. The introduction to international. This series will continue. This is a model sample, and on demand, on subscription, this series will continue. But you have to understand this way. Whatsoever the field you choose, this subject matter relevant and important for all types of examination. Thank you.